because I would like to concentrate more on topics on which you can expect questions in the next month or so. Of course, there will be many more new topics coming after today. So that also you please keep track of those topics. What I am going to do today is not exactly taking a class, because I don't think current affairs can be taught in a class. Rather, I will like to have a discussion, and as Rajuji mentioned, it will be much better if you can keep your cameras on, so that I'm talking to a black board or a screen, and there will not be any question answer session. So if you have any questions, please raise your hand as I am talking, and so that you can participate in the discussion. Don't make it a monologue. I will not like to have myself talking for the next hour and a half or two. I will rather prefer that all of us talk. All of us should participate in the discussion, and there may be some topics where some of you may have more expertise than I have. I'm not an expert in any of these topics. I am able to talk to you because of the 20 years that separates you and me. Otherwise, you are much more conversant with the current affairs than I am. So try to make it a conversation, discussion, and please try to contribute some important points which I may have missed. Okay. Now, another purpose which I want to maintain throughout my talk is that I'm not going to tell you many things about these issues. I will only try to tell you what type of questions you can expect in a civil service interview, how the UPSC would be looking at, UPSC panel would be looking at these issues, and what are the likely issues they might raise. So you are free to raise issues of your own, in addition to the issues which I have raised in the presentation. If you feel that there are some other points which need to be discussed, which deserve to be discussed, please come forward and discuss those issues also. That way, every one of you will benefit. Don't restrict the knowledge to yourself. Please share it with others so that all of you benefit and all of you can help each other to have a better interview. And the approach to civil service interview, of course, I have been mentioning it during the mock interviews and the group mock, of course, I've been mentioning it, but some of about these topics also I will mention to you as we progress along. Okay, now let me start with one very, very topical issue, very, very hotly debated issue. And all these topics which I am going to discuss, I think 4 or 5 or 6 topics are there. I don't know whether I will be able to finish all 6 of them. I'll try to finish all 6 if possible, or as and when all the 6 are finished, we will stop the class. So the nation is divided into 2 groups in all these issues, except probably one last issue. Otherwise, that there also the nation is divided, but not equally divided. But in the all the other issues, quite a large number of people are for the issue, quite a large number against the issue also. It may not be 50-50 split, but somewhere around 50-50. So that way, these issues do not have a final answer. None of you will be able to say that this is the right answer. This is the only right answer. There is nothing like a right and wrong answer in any of these issues. Your viewpoint will be respected, provided you are able to present it in the UPSC interview with good logic, reasoning, and conviction. That is very important. You may not go by the majority view. It's not necessary also. You are independent, you are free-thinking persons, and our constitution gives all of us the freedom to express ourselves without necessarily subscribing to the majority view. So that way you can hold your own view, provided it is not too radical in nature, it is not too extreme, either extreme. Try to remain balanced, try to remain as far as possible a neutral person, and respect the opposite side also. Every side, every thinking, every idea which you may have will have an opposite view also. And you must respect the opposite view. And during the course of your answer, you should never insist that what I am saying is the only right thing. There could be other viewpoints also, which could also be equally right. So let us start with the first topic, that is the okay. These are the 6 topics I am going to cover. You can make a note of these 6 topics and prepare yourself for the discussion. And if you want me to take any of these before the others, please feel free to vote for it. You can mention it in the chat box. And Dr. Patel, are you there?
Sir, Sandeep Trivedi is here, sir.
Sandeep, please keep a track of the chat box. Please tell me if there is any topic which the group wants to discuss in advance, or rather than going by the order in which I have shown here.
Sure, sir.
But the first 2 topics I will take together. Please don't do any marking on the screen. The first 2 topics are connected to each other, so I will take both these together. And after that, you can tell me through your chat box which topics you would like to discuss. Okay. Defamation is a very, very favorite topic for civil service interview, because it has been very popular for a long time. And the last word is yet to be written on the issue of defamation. It is still an evolving legal issue. And our jurisprudence has divided, jurisprudence all over the world has divided defamation into 2 categories, civil and criminal. Civil defamation does not come under any written law. It is punishable under the law of torts, which does not, there is no law of torts in India, but it has been there through convention and through judgments over a period of time. And of course, we have borrowed it from the British law, and the law of torts does exist, but not in the written form. It is there in the form of various judgments and conventions. So under the law of torts, civil defamation can be punished. And in the case of criminal defamation, it is covered under section 499 IPC, read with section 500, which provides for the punishment. And punishment is maximum 2 years imprisonment, which is the punishment which has been awarded to Sri Rahul Gandhi. And the 3 components which are essential for a defamation suit to succeed in a court of law: 1, that there should be a defamatory content, that there should be an express a very clearly expressed defamation in the word used by the accused person, the content has to be established before the court of law. The second is that it must purport to a person or a class of persons. We will examine all this in the light of the Rahul Gandhi judgment. It is addressed to a person. It is a person or a class of persons which has been defamed. Class of persons also needs to be defined clearly. And the third component which has to be satisfied is it has to be published in an oral or written form. Is there any law graduate in the group? Please feel free to share your legal knowledge with us. Anyone who has done good work on this topic, please feel free to express yourself so that we all benefit by your expertise. Now, section 499 IPC, I'm not going to read it in full. You please read it yourself. All the components which I have mentioned are there in this definition. Whoever by words, either spoken or intended to be read, or by signs or by visible representations, makes or publishes any imputation concerning a person intending or knowing or having reason intending to harm, or knowing or having reason to believe that such imputation will harm, that is the content. The reputation of such person is said, except in cases hereinafter expected, to defame that person. Here the definition gives only such person, but such group of persons is also included. There are a number of exceptions which are mentioned. These are all very important in the future proceedings of the Rahul Gandhi case. You will see it as we go along, as you will be reading in the newspapers about the appeal which is likely to be filed by Shri Rahul Gandhi, and what are the type of issues which his lawyer is going to raise in the appellate court. Many of these exceptions will be relevant there.
Sir?
Yes, please.
Sir, are member of parliaments also considered public servants?
Yes, they are public servants.
Thank you, sir.
Parliament are public servants.
Thank you, sir.
But it is here the exception, you see the second exception, it is public conduct of public servants. There is these are the things which are going to be debated and discussed. Whether it was a public conduct or was it, and there are many issues where the conduct of public servants, even public servants, even the case of civil servants also, many of their conduct cannot be considered subject matter of 499 IPC. There are exceptions there also. But then all these exceptions, there are court cases, there are several court judgments in respect of all these exceptions. Imputation of truth with the public good, which public good requires to be made or published, public conduct of public servants, conduct of any person touching any public question, publication of reports of proceedings of courts, merits of cases decided in the court, or conduct of witnesses and others concerned, merits of public performance, censure passed in good faith by person having lawful authority over another, accusation preferred in good faith to authorize the person, imputations made in good faith by person for protection of his or others' interests, and caution intended for good of person to whom conveyed or for public good. Here, many of these exceptions, the legal team of Sri Rahul Gandhi are likely to claim that he has the protection of some of these exceptions. We like to wait and see what all arguments are going to be advanced. And there are any number of case laws related to defamation. Even some of the very highly respected political personalities, artists, cinema personalities, many of them have filed cases against somebody else. There are case laws touching all those cases. You may like to read some of them, but one case law which I have found most appropriate is the one which I have mentioned here, Subramanian Swamy versus Union of India. Is a 2016 judgment of the Supreme Court. There it defined. In fact, this is going to be very important when we discuss the Rahul Gandhi case. Reputation being an inherent component of Article 21. We do not, this is the Supreme Court judgment, I have quoted it as such, the relevant portion. Reputation being an inherent component of Article 21, we do not think it should be allowed to be sullied solely because another individual can have its freedom. It is not a restriction that has an inevitable consequence which impairs circulation of thought and ideas. In fact, it is controlled regard being had to another person's right to go to court and state that he has been wronged and abused. He can make recourse to a procedure recognized and accepted in law to retrieve and redeem his reputation. Therefore, the balance between the two rights need to be struck. Reputation of one cannot be allowed to be crucified at the altar of the other's right of the there is some clash between Article 19 and Article 21. Article 19 gives us the freedom of speech, but Article 21 gives us the freedom of dignity. So where there is some, there can be some clash between these two articles. The gist of what Supreme Court has mentioned in Subramanian Swamy case is that your right stops where my right begins. This has to be understood very clearly, that where the Article 21 right begins, Article 19 right will cease, and vice versa. So this has to be made, this has to be understood very clearly when you answer questions related to the right of individuals, the fundamental rights of individuals. Now, coming to the Rahul Gandhi conviction, I don't want to give you the details because I'm sure all of you are familiar with it. So I just casually mentioned in this slide that it is a 2019 case over Rahul Gandhi's remarks about the Modi surname. All of you must have read the statement which he had made. The court also approved Gandhi's bail on a surety of rupees 15,000 and suspended the sentence. This word suspended is very important. It didn't stay the sentence. Because staying can be done only by a higher court. The trial court has suspended the sentence for 30 days to allow him to appeal. So the right course available to the accused person was to go for an appeal and get a stay from the appellate court. Stay on the conviction, stay on the sentence. If that had happened, the disqualification also could have been avoided. But since that was not, of course, it could not have been done in a day's time. So naturally, there will be some gap during which time the disqualification will take into effect. We'll deal with the disqualification after this. Now coming to the, we'll first talk about the defamation part, then we will go to the disqualification part. In Shreya Singhal case, all of you must be familiar with this. That's also a very classic case. Shreya Singhal case was the one where the section 66 of the Information Technology Act was held ultra vires the Constitution. In Shreya Singhal case, the two-judge bench had held that for something to be defamatory, injury to reputation is a basic ingredient. The bench, the bench had in that case, Shreya Singhal case, added that something may be grossly offensive and may annoy or be inconvenient to somebody without at all affecting his reputation. So here, if the complainant, if it can be proved by the defense that it might have annoyed the complainant, it might have been inconvenient to him, but it did not affect his reputation, then this judgment may not have been proper. Similarly, causing harm to the reputation of a person is the basis on which the offense is founded, and mens rea is a condition precedent to constitute the said offense. Mens rea means the intent. Intent has to be there, and without, if the intent has not been there, it is not possible to consider it as an offense, as a punishable offense. So here, I not gone through the full judgment. I have only seen because the judgment is in Gujarati, I have not been able to go through it. If anybody has gone through it, please, you can share the details with us. But otherwise, what I could go through it is that the court has taken exception to the fact that the accused person does not apologize for causing some kind of defamation to the Modi community. Had there been an apology to that effect, probably this judgment may not have come. So that was the reason which has been quoted by the judge. So by not expressing guilt, not expressing not expressing that I may have wronged the community, I may have brought some I might have some injury to the reputation of the community. The intent seems to be established that yes, there was an intention behind causing injury, the intention of causing injury to the reputation of a certain group of persons. It is not a community. Modi is not a community. It is a number of communities who use the members of whom use the surname. So if that intent was not there, then probably the accused person could have mentioned it in the court and said that I'm sorry for if it has caused injury, it has caused a grievous injury to the reputation of anybody or any community. I'm sorry for that. That would have been the end of the matter. But that has not happened. Therefore, the mens rea is established in this case. That is what the judgment, that is the reason for this judgment. Another very, when we look at the offense of defamation of a community or a group of persons, this particular, I have gone through the case laws related to several film stars, but one I thought it would be appropriate in the present contest is the one filed by Khushbu. Khushbu, as all of you know, that she's a very famous film star. She started with the Hindi films, but then migrated to the South, and there she became a superstar. She had made a statement about extramarital relation, the premarital relations. And one person, one lady, gave the interpretation to Khushbu's remark that it was meant to defame the entire community of Tamilian women. That it gives an impression that all Tamil women have premarital relations. This type of interpretation was given, and she filed a defamation suit against actress Khushbu, and and some others also went to the court. A number of court cases were there against the actress. So she then went to the High Court, but didn't get the relief. So she went to the Supreme Court, and finally the Supreme Court gave her the relief. And some of the observations are: if a magistrate were to take cognizance of the offense of defamation on a complaint filed by one who is not an aggrieved person, the trial and conviction of an accused in such a case by the magistrate would be void and illegal. Now, here it is to be seen whether the complainant, Mr. Punish Modi, whether he can be considered an aggrieved person or not. This has to be seen by the appellate court now. In case the identity of the collection of persons is not established so as to be relatable to the defamatory words or imputations, the complainant is not maintainable. Now, here Rahul Gandhi's lawyers can take the view that Modi is not a well-defined community, so the words cannot be considered defamatory to any particular community. In case a class is mentioned, if such class is indefinite, that is like in the case of Modi community or the Modi persons with the Modi surname, the complaint cannot be entertained. Furthermore, if it is not possible to ascertain the composition of such a class, the criminal prosecution cannot proceed. Now you can take your own, you can have your own interpretations of this judgment, and you can also wait for the arguments which Sri Rahul Gandhi is going to take in the appellate court. That will all come in the newspapers very soon. And if your interview is after that, you can make use of those arguments also in your answer. Now let us come to the issue of disqualification. How does this conviction of Sri Rahul Gandhi constitutes a disqualification? There, we will go to the legal aspects a little later. The two laws which are relevant, we will go there. But to give you some perspective of the issue, let us examine the famous Supreme Court case called the Lily Thomas case, which has become very popular, and it keeps getting quoted in the newspapers whenever Rahul Gandhi case is there. Or the Faisal case, the Muhammad Faisal case, the Lashadip MP who was disqualified, that in that case also Lily Thomas case was quoted. We will go to the law after that, but what has been mentioned in the Lily Thomas case by the Supreme Court is very, very relevant. Let us examine that first. Section 8(4) of the Representation of People Act said that the disqualification takes effect only after 3 months have elapsed from the date of conviction. Within that period, the convicted lawmaker could have filed an appeal against the sentence before a higher court. And this is based on the provision which existed in section 8.4. So let us go to section 8.4 and then we'll come back to Lily Thomas case. Section 8 of Representation of Peoples Act 1951. Section 8.3 says a person convicted of any offense and sentenced to imprisonment for not less than 2 years shall be disqualified from the date of such conviction and shall continue to be disqualified for a further period of 6 years since his release. So in the case of Sri Rahul Gandhi, he has been convicted for 2 years. So this clause 8.3 will be applicable there. Now the question here is, who is to disqualify him? That is where the Lily Thomas case becomes relevant. Here it says a person convicted of and not for imprisonment not less than 2 years shall be disqualified. That is the word. It does not mention here who will disqualify. Whether it is the court who will disqualify, whether it is the Lok Sabha Secretariat who will, it does not mention at all. So the interpretation here in Lily Thomas case is that as soon as the judgment, the conviction has been announced by the court, if it is more than 2 years, not less than 2 years, then the person shall be disqualified. That means there is no necessity for an order of disqualification from the Lok Sabha Secretariat in this case. But in spite of that, Sri Rahul Gandhi attended the Lok Sabha. Having been disqualified under this law, he had no right to appear in the Lok Sabha as a member. That is why the Lok Sabha Secretariat had to issue that notification. Otherwise, there was no need for such a notification at all. Because the law is very clear that he stood disqualified on the date on which the conviction was announced. Oh, sorry, 8.4 is not there in this. Okay. 8.4, I forgot to mention here. 8.4. Okay. Okay. All right. 8.4 gives an exemption to members who are sitting members of the Lok Sabha and the Vidhan Sabha. They will not be disqualified till they get a chance to appeal against it, for which there is a period of 3 months allowed for them. Okay, let us go back to Lily Thomas case. Then that will be made very clear. Okay, the last paragraph in this slide, that is section 8.4. If any sitting member of parliament or state legislature is convicted of any offense under subsection 1, 2, and 3 of section 8, Representation of Peoples Act, then by virtue of such conviction and or sentence, they will be disqualified. The court, okay, this is 8.4 mentioned that they will not be disqualified, but in Lily Thomas case, the Supreme Court held that they will be disqualified. That is, section 8.4 of RPA was considered ultra vires the Constitution, and it stands deleted now. It has been deleted from the statute books. And that is why it is. I didn't mention it in the section when on the slide on section 8. But this is exactly what section 8.4 says, that if any sitting member of parliament or state legislature is convicted, he will not be disqualified till he has availed that 3 months time to appeal against the case. Now, in this Lily Thomas case was filed by a lawyer, Lily Thomas. She's no more now. When she filed the case, she was almost 85, and she's no more now. And another complainant was there. There's a NGO called the Lok Prahari. They challenged the section 8(4) of the RPA as ultra-virus to the Constitution, which protects convicted legislatures from disqualification on account of their appeals pending before the higher courts. On July 10, 2013, Supreme Court held that the Parliament had no power to enact subsection 4 of section 8 of the Act, and accordingly, subsection 4 of RPA, section 8 RPA Act was held ultra-virus the Constitution. It is the Supreme Court held that the elected members do not have any special right as compared to candidates for an election. Candidates would be disqualified under the earlier law. Candidates could be disqualified, but sitting members had a 3 months saving period. That the court said that it is ultra-virus the Constitution. It is against the principle of equal rights. So therefore, it was deleted from the statute books. Section 8 of the Representation of People Act has to be read along with Article 102 of the Constitution, which deals with the disqualifications for membership. There are a number of situations there. 1, A, B, C, D I have deleted. I have not mentioned. You can go through it later because I have only included what is relevant to the present case. 1E, which is quoted in the newspapers, says if he is so disqualified by or under any law made by Parliament. In the present case, it is a law made by the Parliament, that is the Representation of People's Act. The explanation: for the purpose of this clause, a person shall not be deemed to hold an office of profit under the government of India or the government of any state by reason only that he is a minister either for the union or that is not relevant in this case. A person shall be disqualified for being a member of either House of Parliament if he is so disqualified under the 10th schedule. Now, 10th schedule is also very important, but I'm not going to spend time on 10th schedule because it deals with the disqualification under other provisions of law. Okay. There you may like to go through the Muhammad Faisal case also. The Retd MP who was convicted for an attempt to murder. He was sentenced to 10 years imprisonment, and naturally he lost his membership of the Lok Sabha. But then he went to the higher court. He went to the Kerala High Court, which has the jurisdiction over Retd also, and he got a stay. It is not merely a suspension of sentence by the trial court, but he got a stay from the Kerala High Court, which should have been respected by the Lok Sabha Secretariat. Somehow, Lok Sabha Secretariat delayed action on the stay order issued by the High Court, and only when Muhammad Faisal went to the Supreme Court, and on the date of hearing, the Lok Sabha Secretariat gave an affidavit stating that we have already issued a notification withdrawing the earlier notification under which he was disqualified. So he is now eligible to attend the Lok Sabha Secretariat till the time if the conviction is upheld by the appellate court. Naturally, he will lose his he will face disqualification again. Otherwise, till that time, he does not have any disqualification. So in the Rahul Gandhi case also, in case the court stays the proceedings, for the higher court, the appellate court stays the sentence or the conviction, in that case, the disqualification will automatically cease. In the 2018 decision of in the Lok Prahari versus Union of India case, the Supreme Court clarified that the disqualification will not operate from the date of the stay of conviction by the appellate court. So that will be applicable in the case of the Rahul Gandhi case also. Now I will stop here. If you have any, if you like to discuss this issue, please feel free to discuss. Please switch on your microphone and if you don't want to use the microphone, you can write it in the chat box. I open the chat box. You can. I will read it, and but I will rather prefer that you.
Good evening, sir.
Okay, please announce your name and.
Sir, good evening, sir. I am Utkarsh Tripathi. Sir, my
Okay.
question is that if they ask that is defamation punishment as a punishment itself, is it correct? So what all 4 points should be mentioned at the start?
Defamation in this case, it is a punishment because if it is under section 499 IPC, the punishment under section 500 IPC, it is criminal. It is a criminal conviction.
Yes, sir. That the issue that we should be having defamation as a thing of punishment.
Yes, it is a criminal. It is considered a criminal defamation. That is enough to be for punishment. But the
Yes,
quantum of punishment is subject matter for debate. But
yes, sir. That issue, sir.
Okay, so suppose there are two stages of conviction. One stage is where the court holds a person guilty or not. In this present case, the court must have held Mr. Rahul Gandhi guilty of section 499 IPC, the offense under section 499 IPC. That must have been established, that must have been announced also. Then he would have given both the lawyers to debate the quantum of punishment. That also must have taken place. I am assuming because that is how civil criminal courts function.
So, like I'm asking that if it is asked that the defamation has been abolished in countries like UK, Australia, New Zealand, so should it be abolished in India?
No, that is a major issue. Whether it should be abolished or not, I agree that this needs to be debated, and the Supreme Court has to take a view on that. The Parliament also has to take a view whether defamation should be continued or should we follow the example of some advanced countries who have scrapped the defamation. They have removed the defamation clause from their statutes. So that is an issue which need to be discussed. I am not here to discuss that issue because that stands in our statute. If it is there in the statute, the court has to respect that. If the judge feels that defamation should not be punished, he is free to have his personal opinion. But as a court, he cannot go by that, by his own personal convictions. He has to go with the law of the land. The law of the land, under the law of the land, defamation is a punishable offense. Now we can definitely debate this issue whether it should be there or not.
Sir, I agree with what you're saying, but if we look at the issue from the minds of the UPSC panelists, so the probable question will be this: that whether do you think that we should change our laws, and whether defamation should be there as a criminal definition, should be an offense or it should not be an offense? So I think so that is the issue that will probably question that will be asked, and we should highlight
whether it is a civil defamation or criminal defamation. There are a number of number of cases where this distinction has been drawn, but see, it is up to the complainant. The complainant has gone to a criminal court. complainant has complained, he has not asked for civil damages. He has not gone to a civil court asking for damages. In that case, it would have been dealt as a civil offense and damages could have been awarded. But in this case, he has gone to a criminal court and filed a complaint under Section 499 IPC. So the court has no option there. Court has to deal with it as a criminal offense. There are many cases where people have asked for damages, 1 crore, 10 crores damages, but that is all civil offenses. There is no conviction. There is only damages are to be awarded. The components are more or less the same, but in one case, the person is not looking for a conviction. He is only looking for damages to compensate his loss of reputation. So that is for the complainant to decide, not for the court to decide.
Sir, the question is, if the UPSC panel asks us that
Yeah.
should defamation be decriminalized, and given the political scenario that we follow parliamentary democracy,
Yes.
should there be a criminalization of defamation owing to fall of the government or something else?
Okay. I get your point. I'll go back to the Subramanian Swamy case. Here, Subramanian Swamy case, the Supreme Court has mentioned it very clearly that where my right under Article 21 begins, your right under Article 19 stops. Now, if you want to remove defamation clause from the statute books, because of Article 19, which gives freedom of speech, then what about Article 21, which guarantees dignity of the freedom of dignity to individuals? So, if somebody is bringing a disrepute to me, somebody is damaging my reputation, am I not entitled to claim damage? Of course, the question can be there, can it be civil or criminal? I'm not going into that issue. You can discuss that also, that whether it should be treated as a civil offense, whether it should be treated as a criminal offense. That is up to you to decide. I'm not. I feel that if, as Supreme Court mentioned very clearly in the Subramanian Swamy case, that if somebody is damaging the reputation of another person, that person needs to be punished. Merely awarding damages may not have a deterrent effect on such persons. That is what Supreme Court has made clear in this case. That if we don't punish people, treating it as a criminal offense, people may continue to slander others. People have been doing it. There are some people who are in the habit of doing it. There are some journalists, there are some politicians who are in the habit of throwing mud at others. And they will not be stopped unless they are punished. Merely awarding damages may not be enough deterrent. That is the reason why the Parliament is not considering removal of or decriminalizing defamation. That is my understanding, that Parliament is not interested, because Parliament has seen that there have been number of cases where people have been misusing this facility, that okay, if I have damaged you, I will give you compensation. But the moment I know that I am going to be punished by imprisonment, I may stop. So the society, the social circumstances also need to be considered. Our social situation is quite different from what you see in the UK or USA. It's quite different. Our social setup is different. Our habits are different. So probably we may need it for some more time. Maybe a time would come when we can think of removing it from our statute books. But right now, my feeling is that the time has not yet come. You are free to have your own views. I'm not imposing my view on you. I'm only saying that this is how I feel, and this is how Parliament is also looking at this issue. I'll just take a one minute break. Let me get some tea. My tea is ready. So just 1 minute. In the meanwhile, please think of other issues. I'll come back to you in a moment. Okay, ready. Any more question? Okay, there's something on the chat box. Okay, please put yourself in the position of the UPSC panel and start asking questions. I want you to ask questions. This is an exercise. Instead of I've been asking questions, but I want you to ask questions. Please feel free to ask questions. What all questions you anticipate from UPSC?
Sir, can I read out from the chat box what some of the candidates have put across? Dr. Prasanna, sir? Sir, can I read out from the chat box, sir?
Sandeep sir, your voice is very low. Sound is very low.
Okay. Is it better, Mr. Dharamveer? Is it better now?
No, sir, it is still very low.
Okay. I think there is some problem.
You must have, all of you must have thought about this issue. What all possible questions can be there?
Sir, can the panel also ask some questions on Rahul Gandhi's speech in the UK, where he said that democracy is in danger?
Yes, certainly. Yeah, see, there is no limit to the type of questions they can ask. They can ask any question, and there is no limit to what you can answer. If you have gone through the article to that news item, you can. This is something which I've been telling all of you, that please try to make your interview a discussion rather than a question answer session. If you make it a discussion, you can rest assured that you get good marks. But if it is merely a question answer session, almost certainly you are not going to get high marks. That is the reason.
So like this only, the very question that was asked just now, that do you concur with the view that Rahul Gandhi said in what Rahul Gandhi said in UK? So sir, if I answer is
please answer that. Please answer that question. Please answer.
Sir, if I answer it like I do not think that India's democracy is under threat because of the following reasons. First, second, third, fourth. So, sir,
Okay, yes.
is this
Okay.
But is this a discussion
don't give too
forum
many
or-
reasons. Don't give too many reasons. Don't make it a lengthy answer.
Okay, sir. So, sir,
Okay.
how to make this answer a
Okay,
discussion and not a question answer?
Okay.
Yes.
How you make it a discussion is that see, when you are answering the question, it should naturally lead to another question. The way you answer the questions, try to give hints to the panel to ask more questions on that same topic. But if you don't give that type of a hint in your answer, if you just give a factual answer without expressing your view, naturally they may not ask any further question on that. Mention that this is how I feel, and you try to give some logical reasoning also, that why you think that there is a democracy is not under threat. Give one or two good reasons. Don't give too many reasons. Just give one or two very sound reasons on which further questions can come. Similarly, you can
Yes.
also say that if at all somebody, of course, we all have complaints about our democracy. All of us can have complaint about the way our democracy is functioning. We may not be 100% satisfied with what we have right now. We may not be happy with the quality of the discussions in the parliament. We may not be happy with the way the judiciary is functioning. All these things are possible. But at the same time, what is the forum where this issue should be raised? Should it be raised in Cambridge University? Should it be raised before some other foreigners? Or should it not be raised in the parliament itself? These are the issues. We have plenty of other opportunities. We have a very good, very strong media. Both written media and printed media, as well as the audiovisual media. Why not use these to express your grievances against the system, rather than going to somebody else who is looking for finding fault with us? That is not a statesman-like behavior. That is a typical politician's behavior, which we do not expect senior leaders to. We don't expect the typical political maneuvering on the part of the senior leaders. We expect them to behave like statesmen. For them, the nation should be first, and being in opposition does not mean that we should undermine the importance of the nation. You know that when the Congress government was in power, they had sent Mr. Atal Bihari Vajpayee as the spokesperson of the leader of the Indian team, because though Vajpayee was the leader of the opposition at that time. But why did they think of sending Vajpayee? Because they knew that he would be able to present the case better, and he had his first love is for the country, not for his party. That is what makes a difference. That is the difference between a statesman and a politician. A statesman loves the country first. The party comes second. A politician loves the party first and doesn't bother about the nation.
Sir, for the candidates who are already in service,
Yes.
Are we allowed by the code of conduct to talk about certain issues, or should we avoid it, sir, in the interview?
I am very happy that you asked this question. Dharamir, yes, you have. Last year also you heard. I had interviewed you, I think.
Yes, sir. Yes, sir. Last year,
Yes, I remember you. Yes.
Yes, sir. Thank you, sir.
Okay, you are in service now. Yes. No.
IRS customs, sir. Yes, sir.
Okay. What I will like to tell you and all of you together, that please don't. Please think that you are going to be civil servants. Some of you are already civil servants. Others are going to become civil servants. There are certain code of conduct expected from a civil servant. a civil servant may have grievances against the government. Quite possible. You may not agree to everything that the government asks you to do. You are free to express your grievances. You are free to express your dissent on the office file. You can do that. But you are not expected to express it in a public forum. Because you are prevented by the code of conduct from expressing your grievances against the authorities, against the government in a public forum. You are not supposed to do that. But UPSC interview board is not a public forum. There you can definitely criticize the government. You can say if you do not agree with something which the government is doing, you are free to express your views. There is no problem. Code of conduct will not come in the way. But one thing which I will like to tell you, that please don't make a negative comment. Try to make a comment in a positive way. I'm sure I've spoken about it earlier also, but for those of you who may not have heard my earlier discussions on this subject, suppose if you say that the government is wrong in doing this, that is a negative comment. But the same thing you can say that government could have done it this way. That is a positive approach. As a civil servant, the best way for you to behave is to express things in a positive way. Give suggestions rather than complaints. Never say that government has made a mistake in doing this. Instead of that, you should say government could have done it this way. Both have the same meaning, but one is positive and the other is negative. So though you are not, your code of conduct does not prevent you from expressing yourself in the UPSC board, as a future civil servant, please develop the habit of looking at things in a positive way. And that will help you in the long run also. That it will also help you in getting over possible depression. Sometimes people get depressed. Suppose if they are not getting good treatment in the bureaucracy, people develop depression. But if you have the habit of looking at things in a positive way, if you have a positive attitude, you can almost certainly prevent depression in your career. Depression does take place in civil service. I know several civil servants who have suffered from depression, but that is mainly because of the negative mindset. If they have a positive mindset, even an adversity will not affect them too much. Adversity will be there in civil service career. There could be situations where you will face adversity. But if you can look at it in a positive way and try to learn some lessons and try to reduce the damage to the extent possible, then you may not get into the problem of depression. So it is always better that even the UPSC interview also, you maintain that same attitude, looking at things in a positive way, rather than as a fault-finding type of personality. Try to think as yourself as a problem-solving personality. I am coming to civil service to solve problems. I am not there to find fault with others. That should be your attitude. If you can develop that attitude, then whatever answer you give in the UPSC board, there is no problem. It does not attract code of conduct at all, even though you are in service. Don't worry about it. Anything else? Any more?
Thank you, sir.
Any more observations on this? Otherwise, we can go to the next topic. Same-sex marriage is why I have put this in because UPSC, this is one favorite topic in UPSC nowadays. In because we are getting feedback from candidates. There are a number of questions because these are issues which as civil servants you will come across in your civil service career also. Particularly if you are a IAS or IPS officer, you are going to deal with this type of issues. Issues of adultery, issues of same-sex marriage, issues of LGBT community, issues related to defamation also, issues of somebody may even file a case against you for defamation for some remarks you may have made during your official meetings. All these things are possible. I have also faced a defamation case, but nothing came out of it. That's a different thing. I didn't even get a summon, but some people had gone against me also. So these type of things will happen in civil service career. So it is social issues are going to be very, very relevant in UPSC interview. That is why I had taken some of the social issues. We can have a brief discussion on these issues. Same-sex marriage is a very current issue because the Supreme Court has expressed some views. It has, the final word is yet to come, but Supreme Court has mentioned that same-sex marriage is a seminal issue. And there are different viewpoints on this. People are not, the Indian society does not have the same voice as far as same-sex marriage is concerned. So Supreme Court decided that it will be decided by a constitutional bench. The petitioners have cited that right to marry cannot be withheld from a section of people based solely on their sexual orientation. The center center has given a very, very balanced kind of a viewpoint. The center has opposed in the Supreme Court that a batch of pleas seeking legal validation of same-sex marriage, saying that it would cause complete havoc with the delicate balance of personal laws and accepted societal values. We can have a discussion on this issue. Despite the decriminalization of Section 377 of the Indian Penal Code, the petitioners cannot claim a fundamental right for same-sex marriage to be recognized under the laws of the country. Okay, I'll go through the next slide also, then we can have the discussion. Let us be very clear about the issues involved. Now, some very interesting things you can notice here. Section 5 of Hindu Marriage Act, as well as the corresponding section of the Christian Marriage Act, it does not mention marriage between a man and a woman. It does not mention both these acts. Hindu Marriage Act mentions a marriage may be solemnized between any two Hindus. It does not mention the sex of the persons. Maybe it was at that time when this act was framed, and when the Christian Marriage Act was framed, that was in the 19th century, nobody might have thought about same-sex marriage at that time. Probably because of that, they didn't deem it necessary to mention the gender of the persons. But the fact is that today, it can be interpreted in a different way. So between any two Hindus, if the following conditions are fulfilled, a number of conditions are there. The fourth condition I have quoted here, the parties are not within the degrees of prohibited relationship unless the custom or usage governing each of them permits of a marriage between the two. That is important in our discussion, that there is a custom or usage or a social norms are there which prohibits the relationship. In that case, it cannot be, the marriage cannot be solemnized. The expression custom and usage signify any rule which, having been continuously and uniformly observed for a long time, has obtained the force of law among Hindus in any local area, tribe, community, group, or family. Here, one word is very important: in any local area, tribe, community. This phrase is very important, because what is followed in one community may not be, one part of Hindu religion may not be applicable to another community of Hindu religion. What is followed in one local area may not be applicable in another area. For example, in some parts of the country, marriage between two near relatives is forbidden. In North India, especially, marriage between the same gotra is forbidden. It's considered to be a sin. Whereas in some other parts of the country, marriage between first cousins is not considered a sin. It was quite okay in some communities. So when we talk about custom and usage, it relates to that particular area, tribe, community, group, or family. That is very important. There is also a proviso that provided the rule is certain and not unreasonable or opposed to public policy. That is also very important. There is a question of a constitutional morality as against social morality, where there is a clash between social morality and constitutional morality. The law courts will recognize only constitutional morality. It may not go by the social morality. But social morality is also important. When we had to deal with this type of cases, social morality is also important, but constitutional morality will prevail over social morality. So if some marriage is prohibited under the social custom, but allowed under the constitutional law, probably the courts may not consider it illegal. But there have been situations where courts have considered them illegal also because it is not within the social norms. So these are very vague areas which need to be addressed, and that is one reason why the Supreme Court is still not in a position to take a decision. The government of India is also not in a position to take a final view on this issue. Another thing, let us continue that. Section 377 IPC. There are a lot of judgments about 377. But this also need to be understood properly. 377 had criminalized the consensual sexual intercourse between persons of the same sex for being against the order of nature. That is, 377 is a very old section, but it has now been decriminalized. In 2009, why I am mentioning all these things, that in the event of a discussion, you can use all this information. Don't restrict your information, your discussion only to what is currently in news. You should have a good idea about the background of the case and also the social system of our country, so that you can have a more meaningful discussion in your interview. In 2009, before the Delhi High Court, the Nas Foundation India Trust challenged the constitutionality of Section 377 for violating Articles 14, 15, 19, and 21 of the Constitution. This used to be one very frequent question in the UPSC of those days. But all of you must have been in the studying at that time, so you may not have come across this, but it's important for you to know about it. The Delhi High Court ruled that punishing sexual activity between two consenting adults under Section 377 violates the right to equality, privacy, and personal liberty of such persons. Now, this was challenged before the Supreme Court. Supreme Court reversed the Nas verdict in Suresh Kumar Kaushal and another versus Nas Foundation and others. Supreme Court held that only the Parliament could decriminalize homosexuality. So the ball is in the court of the parliament. 5 individuals from the LGBTQ community, that case is known as Navdeep Singh Johar case. So if you just go to the, I think I have the slide on that. Navdeep Singh Johar case, Navdeep Johar and 4 others, they had filed a new writ petition challenging the Supreme Court decision. Challenging the decriminalization of 377. (377) criminalizes unnatural sex, which is against the order of nature. The court held that such a classification between natural and unnatural intercourse is not legally valid. Naturalness should not determine the legality of or acceptance of a phenomenon. Penal consequences for such an act that is unnatural or wrong cannot be imposed without sufficient justification. This is the Navdeep Singh Johar case. These are the observations in that. The court described the constitutional morality as the ideals and morals of the Constitution and the values that create an inclusive society. It recognized the Constitution as a tool to transform society. A decision on whether a penal provision violates fundamental rights must be guided by the principles of constitutional morality and not societal morality. Where a constitutional court finds that a provision violates constitutional morality, it must be struck down. The court observed that India is a signatory to the Yogyakarta principles. I have a slide on Yogyakarta principles. Yogyakarta is a town in Indonesia, a city in Indonesia, where this meeting was held. Yogyakarta principles that become something like an international convention which prohibits the discrimination on the grounds of sexual orientation and gender identity. NALSA, that is National Legal Aid Society, versus Legal Aid Authority versus Union of India also relied on these principles, though they are not binding, to uphold the right of non-discrimination on the grounds of gender identity. The court held that Section 377 does not conform with India's international obligations. The court upheld the right to equal citizenship of all members of the LGBTQI community in India. Section 377 will continue to apply to non-consensual sexual activity against adults, sexual acts against minors, and bestiality. Now, this means that Section 377 has not been deleted. It has not been held ultra vires also. Only that criminalization of certain acts under Section 377 has been decriminalized. That is the only difference. But 377 continues to be there. And there can be punishment under 377 for certain offenses. Yogyakarta Principles 2006 Convention, violence, harassment, discrimination, exclusion, stigmatization, and prejudice have been directed against persons because of their sexual orientation or gender identity across the world historically and today. These experiences are compounded by persistent discrimination. Some of the aspects of Yogyakarta, the list which I have given is not complete. Only 4 or 5 I have mentioned. The rest of them are also important. Some of them in that universal application of human rights, right to life, liberty, security and privacy, right to fair trial, freedom from torture, etc. Right to family, right to participate in public life. All these rights have been now given to the LGBTQ community also in our country. That is the judgment of the Supreme Court, and you must be familiar with this case, the Navdeep Singh Johar case, and some other cases related to that. And NALSA versus Union of India, the court upheld the right of all persons to self-identity self-identify their gender. Further, it declared that hijras and eunuchs can legally identify as third gender. Now, in many applications, you will see third gender also. The court clarified that gender identity did not refer to biological characteristics, but rather referred to it as the innate perception of one's gender. Thus, it held that no third gender person should be subjected to any medical examination or biological test which would invade their right to privacy. The court interpreted dignity under Article 21 of the Constitution to include diversity in self-expression, which allowed a person to lead a dignified life. It placed one's gender identity within the framework of the fundamental right to dignity under Article 21. Right to equality under Article 14 of the Constitution and freedom of expression under Article 19 was framed in gender-neutral terms. It says all persons. It does not say all men. Consequently, the right to equality and freedom of expression would extend to transgender persons also, because they are also persons. Somebody is doing highlighting, please avoid that. Let us complete this and then we'll come back to. Okay. Now shall I go through this also, because this is also related. This is a related issue. So let us complete adultery also. Then we'll come back for. We'll start the discussion on that. Adultery has been decriminalized by the Supreme Court, but there are certain areas where adultery still can be punished. We'll come to that. Under Section 497 of the Indian Penal Code, a man who had consensual sexual intercourse with the wife of another man without that husband's consent or connivance could have been punished. That because now it is not there. Now that punishment is not there. Up to 5 years imprisonment or a fine or both. The concept of adultery targeted the act of sexual intercourse occurring between a married woman and a man other than her husband, in which case the man would be guilty, whereas the wife was exempt from punishment. There also the principle of equality was not maintained. When a married man had sexual intercourse with an unmarried woman, no party was punishable. While if a married man had sexual intercourse with a married woman other than his wife, the married man's crime was against the husband of that married woman, not against the man's own wife, towards whom he had been unfaithful. Adultery was only prosecutable upon the complaint of the aggrieved husband or by a party whom the husband has entrusted with the care of his wife. Now, there are a lot of limitations here, lot of things which do not find logical in the present social system. That is why adultery had to be decriminalized, but there are certain riders to that also. Let us see that also. Joseph Shine versus Union of India, you must go through this judgment. Joseph Shine, a non-resident Keralite, filed a PLI challenging the constitutionality of the offense of adultery under Section 497 of IPC, read with Section 192(8)(2) of the CRPC. Section 497 was unconstitutional, as the very basis for criminalizing adultery was the assumption that a woman is considered as property of the husband and cannot have relations outside of marriage. But that is not applicable to men. It was applicable only to women. The same restrictions, however, did not apply in the case of the husband. Section 497 violates the right to privacy as well as the liberty of women by discriminating against married women and perpetuating gender stereotypes. On 27/9/2018, a 5-judge bench of the Supreme Court of India unanimously struck down Section 497 of the IPC as being violative of Article 14, 15, and 21 of the Constitution. But the story does not end there. That is why I have, had the story ended there, I would not have included it in my presentation. On November 5th, 2020, the Union of India filed a miscellaneous application asking the Supreme Court to provide clarity on how the judgment would be applied to members of the armed forces. This is with a specific reference to Section 69 of the Army Act 1950, which punishes members of the armed forces for committing civil offences. The union sought to clarify whether this includes adultery practiced by armed forces members. On January 31st, 2023, that is why it has become a current affair for us. A 5-judge constitutional bench led by Justice K.M. Joseph passed the final order on the matter. It's a constitutional bench decision. The bench clarified that while passing the judgment in 2018, the court was not concerned with the laws of the armed forces and therefore did not stand in their way. That means that while Section 497 has been decriminalized in our country, adultery continues to be an offense under the Conduct Act, Code of Conduct, under the conduct rules of the civil authorities, civil servants, as well as the armed forces also. So, in case a civil servant commits adultery, he or she can be proceeded against departmentally for a conduct unbecoming of a civil servant. Conduct unbecoming of a civil servant has been defined in a number of Supreme Court and High Court judgments. I am not going to deal with that now. Please feel free to find out what is meant by conduct unbecoming of a civil servant. Adultery is one such issue. So, though adultery has been decriminalized, it does not mean that civil servants and armed forces employees can indulge in adultery and get away with it. Okay, we'll come to age of consent after that. And now let us have a discussion on this. Just 1 second, I need a small break. So please think about possible questions. I'll come back in one minute. Okay. What possible questions can come from? Both these issues are going to be very prominent in your UPSC interview. Many of you can expect questions on both these issues: adultery as well as same-sex marriage. Am I audible?
Yes, sir.
Okay. But I'm not hearing any voices. Who would like to discuss?
Sir, you're audible, sir.
Okay. Now I would like to have a discussion on this topic. I have raised some issues, but I will like you also to raise issues. I may
Hello,
al-
sir.
yes,
Am I audible, sir?
yes, please.
Yes,
Please.
sir. So there is a question around this same-sex marriage, that should the court be setting up a committee and deciding on this, because the parliament is the representative body, and it represents the will of the people. So to
Yes.
bring about a law which does not have societal ramifications, only the parliament can do that, sir. What
Yes,
if
ideally, yes, Parliament should come with a law. But you know the political conditions of our country. It is very, very difficult to get the Parliament agreed to any particular view. And there are religious implications also. Some of the religions may not like, when we discuss the age of consent, we'll see more about this type of issues. But the same-sex marriage maybe becoming more and more popular now, with the younger generation accepting it as a fact of life. But the people sitting in the parliament, not all of them are from the younger generation. They may not like to even discuss it. Many of them may be even averse to discussing it. That is why the constitutional bench may have to look at it. Probably constitutional bench may also not like to take a final view on this issue. Probably just as they have done in the case of adultery, they may decriminalize same-sex marriage, but may not encourage it. That is what I feel, that people may not be punished for living together. In any case, this has been going on for quite some time, and there is nothing illegal about persons living together. They may call themselves husband and wife, they may belong to the same sex, but they may call themselves husband and wife. They may even solemnize their marriage. There may be some priests who may like to preside over their marriage and solemnize the marriage. That everything is happening in our society. But at the same time, whether this has a social acceptance or not, that is yet to be seen. As it stands today, social acceptance is an exception rather than the rule.
Sir, since Parliament represents the society in general, and such kind of laws which are against some accepted social norms, they are in the sense delayed because society evolves at a certain pace. So in that sense, I do feel that such actions are better provided by judiciary, because they are faster. They adhere to the rights of the individuals.
That is, I also agree that in fact, I do not think in the near future Parliament will be able to come up with a decision on this topic, whereas the constitutional bench will be in a position to do it. Constitutional bench can get views of various experts on the subject. They can also get the views of various religious leaders. All these things are possible for the Supreme Court. But that type of facility is not available in the Parliament. Parliament, of course, Parliament committee can look into it. Parliament can refer it to the standing committee or a representative committee of both the houses of the Parliament, and that standing committee can seek views of various social leaders, religious leaders, constitutional experts. All these things are possible. But still, I don't think that the Parliament will be in a position to come to a final view about same-sex marriage. Adultery, probably they may agree to decriminalization of that. They have practically agreed to what the Supreme Court has said. But in the case of same-sex marriage, I doubt whether Parliament will come up with a law.
Sir, there may be a question. Sir, there may be a question that the political inaction
Yes.
the politically inconvenient. This issue is a politically inconvenient for the legislature. So, sir, that may raise a question of judicial overreach. Don't you think that it is a vacuum which has been created?
No,
And
it is not a question of judicial overreach. In fact, this is these are issues where the government wants the Supreme Court to give a direction. It is not because the vacuum has been created by the inaction of the parliament. The parliament is not very much in a position to discuss this issue. Therefore, the vacuum has been created. May not be deliberate, but that is because of the social circumstances of our country, and probably the Supreme Court may seek the views of the government of India, where they may seek views of various parts of the society, various representatives of the society, and come to a final conclusion. And it may be in the form of a direction to the parliament also. It's not necessary that they will come up with a final view. They may say that, okay, this is a thing where we will not like to take a view. The parliament should legislate on it. In that case, parliament may be emboldened to discuss it and come up with a final law.
Sir, we do have certain laws like Special Marriage Act is also there, and as we have read about the definitions in the Hindu Marriage Act, it also does not prohibit these kinds of marriage.
Yes, yes, special marriage also, yes.
So already law exists, and the relationship is also decriminalized. And why is it illegal to marry within the same sex?
Right now, it is not illegal. It is not considered illegal. It is not accepted by the society. That is the only problem. Otherwise, there is no punishment for it. It's not a punishment, because even adultery has been decriminalized. So but you see the definition of rape. When we come to the definition of rape, some of the unnatural actions are still within the purview of criminality. Not every act. There is some distinction has to be drawn there. That consensual sex has been decriminalized. Even in the case of rape, some of the exceptions were removed, like marital rape, for example. You must also go through the law regarding marital rape, the 2013 amendment of the CRPC. That also you must go through. I think I have the slide on that. But marital rape, in certain circumstances, is considered rape and is punishable. Earlier, it was an exception. And after the 2013 amendment of IPC and CRPC, it has become a criminal offense under certain circumstances. And what are the circumstances? Please go through the law. But again, the final word is yet to be written about the criminality of these offenses.
Okay, thank you, sir.
Something which is not affecting the social order, which is not affecting the order of the society. The law, it does not create a law and order situation. It doesn't go against any individual or class of persons. Then what is the point in punishing such offenses which are purely private? In our own private life, we also, each one of us may be committing an offense which may be punishable if it is done in public. Many of us would be doing that. As long as it does not affect the rights of another person, it does not affect the rights of the society, it should not be treated as a crime. That is the general viewpoint that is emerging now in our society. And the advanced societies have already done it, and we are still in the process of creating that kind of a social order.
Sir,
Yes.
so what should be the view in this regarding? Because till it is private, it is fine. But the right to marriage also includes other related rights, like right for inheritance.
Right. I couldn't hear the question.
Okay, very sorry, sir. I'll come again.
Okay.
Are you able to hear me now, sir?
It's not very clear.
So now,
Yes, please carry on.
sir, what should be our opinion? Because till it is private, it is a personal right. But right to marriage has also
No. Your voice is not clear. It is
I'll
audible.
type it, sir. I'll type it.
Can you type?
Yes, sir.
Please write it on the chat box. I'll read it.
Sir,
Yes, please.
sir,
Priyanka, yes,
with
please.
coming of same-sex marriages, the traditional notion of family and its functions are slightly deviated. Like
Yes.
because it also includes the giving society new members and their socialization as well.
Yes.
So so that has been a contentious point with regards to the conservative society.
Yes.
So if a question is being asked that whether this viewpoint is right, or maybe there is some question about it, how should we deal?
Okay. I think our sociology students will. Priyanka, what is your optional subject?
Sir, sociology.
Sociology. Then you should be able to answer it better. Okay, I'll give you some hints. Then you can give me an answer to this question. Now, see, there is a concept that marriage is one of the instruments for reproduction or for continuity of the society. Okay, that concept, that is actually a Western concept which we have also subscribed to. Whereas in the ancient Indian society, using the third gender for sexual activities has been prevalent, if you look at the old literature. But naturally, that was not for reproduction. So it had been there in our society. But with the influence of the Western sociology, social thoughts, marriage as a means of prolonging the society, perpetuating the society, has been accepted by our social thinkers also. Now you tell me, as a student of sociology, can you elaborate further on this?
Sir, I think if we look at the institution of marriage, it is going under evolution in itself because of the mixture of thoughts, and also about the transition of culture, and different types of families are also emerging.
Yes.
So with upcoming of easiness of adoption, or certain surrogacy laws are also there, I think this function is somewhat fulfilled as well.
Yeah, you're right. You're right. The things are changing now. Marriage is no longer an essential requirement for society anymore. Okay, even without marriage, society can perpetuate itself. That is how, that we are gradually coming to that thinking. It may not immediately be accepted as a social norm, but gradually the younger generation gradually is accepting it, and many of the people, even if they get married, they don't want children. All these things are also happening in our society. So the society keeps on. Society is, of course, an evolving concept. It is never final. And maybe after some time, many of the things which we didn't consider legal may become legal. Like even in the case of adultery or same-sex marriage or age of consent, all these things, or for that matter, many of the other issues which we had discussed today, in the 1950s or 60s, Supreme Court had not accepted these arguments. There was a case about the LGBT community, the transgenders, the third gender, as we know it. There was some issue which was there in the 1950s, 60s. I don't remember the exact time. That time, the Supreme Court didn't accept the argument at all. But the same Supreme Court in the 21st century has accepted it. So Supreme Court is also changing its stand. Parliament will also change its stand. We will also change our stand. So there is no finality to this view at all. Okay, now let me look at the chat box. Ajay has written here, sir, what should be our opinion on same-sex marriage accepted equally on par with heterosexual marriage? As it has associated laws too, like inheritance, adoption, etc. I think that is what we have discussed now, that it is same-sex marriage or heterosexual marriage is that is the norm of our society, but same-sex marriage, since it is not an instrument for reproduction, it does not get the same treatment as heterosexual marriage when it comes to social norms. But maybe same-sex marriage may come to be decriminalized, but it may not be accepted as a social norm for some more time. That is what I think. But don't ask for what opinion you should hold. I will never force my opinion. I will give some suggestions, but you don't go by my opinions because my opinion is maybe even outdated because I am not as young as you are. So you are free to have your own opinion about all these issues, provided you are able to substantiate it with logical reasoning. And especially those of you with sociology as optional subject can expect questions on same-sex marriage, and there the sociological concept, the social theories which you have studied in your sociology textbook can also be useful. You must try to relate your answer. You must try to explain your position with reference to the social theories which you have learned in your sociology textbook.
Sir,
your answer will be very good. Yes, please.
Sir, the basic idea behind the concept of rights is that, as you said, that my rights stop where others' rights begin. Like
yes.
it should not hurt others' rights.
Yes.
And in many such cases where there is a conflict between the rights of the individual and the rights of the society as a whole, because also in this case, the family of the individual who's marrying within the same sex, they might face social ostracization or disrepute. So their rights are being hurt.
Yes.
So
you're right. You're right. That is why I said the final word is yet to be written. It is going to be very difficult for the Parliament or even for the Supreme Court to take a final view. It is going to be difficult, and the social acceptance also depends on the acceptance by the family.
Yes, sir.
Family is going to have problems. But they may not even why go about this. Like, for example, in a family, if there is a transgender in a family, look at their plight. Some in North India, and for that matter, almost throughout India, such children were not allowed to continue in the family. They were thrown away from the family, and that is how the hijras, many of the hijras you see on the road, they might have been abandoned by their families. But that is unfortunately our social system. There may be some families who are willing to accept them as genuine persons, but most of the families are averse to do that. And in such a situation, the social norms will prevail over individual preferences.
Okay, sir.
Okay, now I had to stop. So let me finish the presentations on the other two topics also. Then maybe we can have more discussion after that. Let me finish this age of consent. It is another very, very important topic in the UPSC interview. Just to give you, I have given some facts which will be useful to you in your discussion in the interview. Hindu Marriage Act, Christian Marriage Act, and Special Marriage Act, all these three set a minimum age of 18 for women and 21 years for men. For Muslims, the criteria is attaining puberty, but puberty is something which has not been defined by law. It can be before 15, it can be after 15, but nobody knows. But so the law assumes that if there is no evidence to prove that a person has attained puberty, then it is assumed that the bride or groom, when they turn 15, they would have attained puberty. That is an assumption. National Commission for Protection of Child Rights, NCPCR, approached the Supreme Court against a ruling. Now, this is a very interesting judgment of the Punjab and Haryana High Court. There was a case where a young Muslim girl, and underage, I think she was 17, 17-year-old Muslim girl, married a person of 36 years old, and there was a habeas corpus. There are 2 or 3 cases, so not one case, 2 or 3 cases which were decided by Punjab and Haryana High Court. In all these cases, it was a case of an underage girl marrying a person who is of a legal age. And the High Court permitted the habeas corpus petition filed by the husband, though it was opposed by the family of the girl. There are some other cases also which you may be able to refer to in your answers. Supreme Court in Shaira Banu versus Union of India had ruled the practice of instant triple talaq constitutional. This means that though the religious law permitted triple talaq, the Supreme Court had held that constitutional law prevails over the religious law. So this is a precedent which has been set by Supreme Court in the triple talaq case. Similarly, protection of children from sexual offences. The POCSO Act does not recognize consent over sexual activity by minors. So on the one hand, the Marriage Acts or the Muslim marriage law allows a minor girl to be married, whereas POCSO Act recognizes it as a punishable offense. So there has to be, in legal terms, there is a term called harmonious construction. When 2 laws give different interpretation of the same fact of case, same facts, then there has to be a harmonious construction of the 2 viewpoints. And Supreme Court has held, and Supreme Court, the case has not gone to Supreme Court so far. It has been decided by Karnataka High Court, Gujarat High Court, Kerala High Court. All these high courts have held in around 2013-14 that no Indian citizen can claim immunity from the Prohibition of Child Marriage Act on the ground of his belonging to a certain religion. That is, the constitution, the law of the land will prevail over the religious law. This has been established by the at least 3 high courts. Then the Union Ministry of Women and Child Development in 2021 introduced an amendment to the PCM Act. Many of you might have gone through that amendment to raise the age of marriage for women, that is from 18 to 21, and ensure uniformity across religions. That is, irrespective of the religion, the age of consent would be 21 for both men and women. But this amendment has not become a law so far. It is still pending in the Parliament. So these are some of the facts. Now, Section 375 IPC also, you must have a good idea about the components of rape. That a man is said to commit rape who, except in case hereinafter exception, there are a number of exceptions that are listed there. I not listed all that. Has sexual intercourse with a woman under circumstances falling under any of the 6 following descriptions. Number 6 descriptions are there. Some of them I have mentioned here: against her will, without her consent, and so on. But what is more relevant for this discussion is that with or without her consent, when she is under 16 years of age. That is not going by the POCSO. It is under 375. Another milestone has been given: 16 years. 18 years is under POCSO, but this was even before that. Under 16, if it is a girl above 16 to 18, if it is consensual sex, it is not punishable. It is not considered rape. The exception is sexual intercourse by a man with his own wife, that is marital rape. The wife not being under 15 years of age is not rape. It is not considered rape under Indian law. The marital rape has not been, again, the final word is yet to be written about marital rape also. Now, let me finish this. Then we'll have the discussion. Independent Thought, a non-governmental organization, filed a writ petition urging the Supreme Court to declare the exception unconstitutional. On 28th August 2017, Child Rights Trust, a non-governmental organization working on prevention of child marriage, joined as an intervener. The Union of India first argued that it was for Parliament to rectify the anomaly created by the exception in Section 375. They further argued that the anomaly had been considered repeatedly by Parliament and a decision was made to retain the classification. Owing to social pressures and the state's reluctance to interfere in marital life. This will answer some of the questions which were raised earlier. The Parliament is reluctant to interfere with our privacy, our personal life. On October 12, 2017, the 2-judge bench, though through 2 concurring opinions, read down exception 2 to Section 375 IPC and raised the age of consent to 18. From 16, it was raised to 18 for the purpose of the exception. It also called for legal reforms to prevent and address violation of girls' rights due to child marriage. Now let me finish this. Okay, Khalistan movement, I will not deal with it now unless we don't have time for that. Now, what I would like you to discuss here in maybe another 5-6 minutes. Okay, it's already past 7. Maybe we can go for another 10-15 minutes more. Please see where we had to draw a line. POCSO Act is very clear that sex with any person below 18 years is considered a rape. Is an offense. Is an offense under POCSO Act. But some of the earlier laws and some of the religious laws do not recognize 18 as the age of consent. It gives a lower age of consent. Now this has to be harmonized. Some harmonization of all these laws have to take place in if the society is going to have a, if you had to say that the society is a progressive society recognizing the rights of the child is not in a position to go to a court. Child is not in a position to articulate his or her rights. So it has to be the society, the legislature, and the judiciary which have to come to the help of the child. And POCSO Act the principles which has been followed by POCSO Act appear to be more reasonable in a society like ours, and the other laws have to be harmonized with it. This is my view. You may not subscribe to my view. You are free to have your own views on it. But now let us have a discussion on it for another 10 minutes. Is there anything on the? Okay.
Sir?
Yes.
So despite all these laws and the boundaries that it has been creating over children, over teenagers or people in engaging the intercourses, we see that the social condition and the sexual activities of teenagers are changing.
Yes.
So they are getting engaged prior to the legal ages, and then there is no legal recourse for it, or maybe there is a huge challenge with regards to controlling their sexual activities and teenage pregnancies. So how do we deal such kind of problems?
I think we are still not mature enough to deal with this issue. I told you about the Khushbu case. Khushbu
Yes,
case is exactly what you are mentioning. Khushbu had, I don't know whether she wrote it or she expressed a view in a television channel in an interview. I don't remember that. What she said is something like this, that pre-marital sex, that is a teenage sex, including, that is, she is not against that. In fact, she accepted that it is quite prevalent in the society, but she advised the girls that you should be careful. You should be very, very careful. You should take the precautions. That is what Khushbu said. Now, a lot of hue and cry was raised against Khushbu for saying this. Now, all of you may not find anything wrong in what she said. But society is yet to accept this type of opinions also. So how do we deal with this type of situations? It's very, very difficult. Even Parliament is reluctant to deal with such situations. So gradually, let us wait for the society to grow to that level. That is the only way out. All these revolutions cannot take place just because we want that revolution. All these things have to be very, very slow changes. We cannot expect a revolution.
Okay, sir.
That is why I said you try to think like a civil servant. Civil servant will not precipitate a decision without considering various aspects. That okay, this is the only right decision. Civil servant will never say that, because there are manifestations of that decision in different ways, which probably we may not understand at all. We may realize the implications of our decision only when somebody tells us. But a good civil servant will foresee the problems which can arise because of our decision, and usually a decision is taken not by an individual but by consensus, by consulting various stakeholders and then coming to a consensus. That is how decisions are taken in government, but consensus is almost likely to evade in a parliamentary discussion. In bureaucracy, it is much easier to take decisions, but in parliament, it is very difficult because consensus is very, very unlikely. Judicial is much easier.
So if asked such kind of questions, can we say that there is certain conflict with regards to the law and the societal norms, and it requires the harmonization with progress of time?
Yes, very correct. That is how you should. That is how a good civil servant will approach it. Because a civil servant will not like to precipitate a decision.
Okay, sir.
Okay, because what I decide for me, it may be right, but for you, it may not be right. But since my decision will affect you also, I have no authority to take that decision without consulting you. That is how civil servant looks at it. So take a neutral stand and look at the pros and cons of the issue and say that, okay, having considered the various aspects of this issue, this is what I feel. I may be wrong, but this is how I feel. But never go to extreme. Never say that this has to be done, because there are other implications also. We should not be blind to the possible implications. Any more discussion?
Sir?
Yes.
So recently the CJI gave a comment that the age of consent can be reduced because it was being misused by parents who were disapproving of interreligious or intercaste relations. So they were reporting to the police about it being under POSCO, and they were also booked under POSCO. So should the age of consent be reduced, or is that a viable thing to do?
See, that is a viewpoint. One way to look at criminalization is to decriminalize many possible acts. In that case, they will not come under the criminal law. They will not be criminal. Suppose the age of consent is reduced to say 12. Naturally, practically POXO Act will cease to be relevant at all. There won't be any punishments under the POXO Act, because that is one way of decriminalizing actions. But is it the right thing to do? Have we ever consulted the children? What they feel? We don't have any mechanism to consult the children. We only consult the parents. And if the parents have a different viewpoint, which may not be acceptable to the children, we have no means of finding out. Because children are not possible, it is not possible for the children to articulate their views.
Yes, sir.
How do we look at it? So we have to go by the experts who have been dealing with children, experts who know the psychology of the children. Okay, we have to go by their view, not by the parents' view. Parents may say that, okay, it is my sweet will. I want to marry my daughter at the age of 15. So who are you to ask me? It is my sweet will. You can say that, but what will be asked that parent? Have you ever consulted your daughter? Is she willing to be married? Is she willing to get married because of her free will? She may be, the parent may have coerced her to agree. Is she accepting the marriage because of her free will? We don't know this way. It is almost impossible to find out.
Okay, sir. Okay, sir. So I have one more question. So shall I ask?
Yes, please.
So recently there was a crackdown in Assam against child marriage.
Yes, yes.
And some individuals were booked under POSCO instead of Prevention of Child Marriages Act. And the punishment under POSCO was much more severe. So there was outcry from the society saying that they should actually be booked under the Child Marriage Act, sir. So what are your views on this, sir?
Have you heard the interview with the Assam Chief Minister? He has explained it. Please have if you just go. I think there is a YouTube interview of the Assam Chief Minister. He has explained why it was necessary. Please go through that.
All right, so I'll see.
Of course, you can say that sometimes some extraordinary solutions may be required in extraordinary situations. This is again another civil service way of looking at things. Some extraordinary circumstances require extraordinary solutions. We have all done it. All civil servants would have done it. Assam, there is a very extraordinary circumstance. The child marriage is very, very prevalent there. Of course, it is there prevalent in Rajasthan also, but maybe it is more prevalent in one community rather than the other. Rajasthan, it is more in the Hindu society, whereas in the Assam, it is in another society. So maybe Rajasthan government may not be interested in annoying the majority community. Assam government may not mind it. That may be the reason. But again, sometimes extraordinary steps have to be taken to deal with extraordinary situations. And
Okay, sir, thank you.
Assam, please go through the interview of the Assam Chief Minister. He has articulated it very well. I will not be able to articulate it so effectively. So I will advise all of you to just Google the interview with just type Assam Chief Minister interview child marriage. If you type these keywords, you will get the interview. You will be able to watch the interview. I have watched it. I found that some of the questions which he has answered is very, very difficult to reject his arguments. You may not agree with all his arguments, but he has to maintain law and order in his state. So he has resorted to extraordinary means for doing that. You cannot find fault with that. In another situation, probably he may not have done it. In another state, it may not be done. So every state, every situation has to be dealt as a separate situation. And you have to come up with a unique solution for that. The same solution may not be applicable in another situation. This you will come across in civil servants' career, that there are many solutions which may appear to be very ridiculous, which may appear to be very, very extreme, but sometimes we have to do that.
Good evening, sir. I want to ask a simple question.
I think this will be the last question. Okay, please, yes.
Sir, for example, there is a often difference of opinion between the parliament and judiciary. For example, with respect to homosexuality or appointment of chief election commissioner or otherwise, there is certain types of tussle. So yes, how do we address it? For example, once you said that parliamentary inactivity has led to judicial activism. Yeah. So can't we say that judicial opaqueness often leads to parliamentary proactive governance with respect to NJAC Act?
Okay, yes, you're right. It is a double-edged sword. It's very difficult to say who is right and who is wrong. After all, in our constitution, the three wings of the government, the legislature, judiciary, and executive, they are very clearly defined, and their domain is also very clearly defined. But there are certain circumstances where overlapping of functions do take place. So if there is a vacuum created by the parliament by not taking action on certain things, the judiciary may have to intervene. So we may think that it is an encroachment onto the parliament's, the legislature's domain. The other way also it is possible when judiciary does not take action against some of its own failures, like for example, punishing the judges who are known to be corrupt. If the judiciary does not do it, then the parliament may also like to intervene. So this give and take does take place in our governance system, but every person in authority knows where to draw the line. It is possible that if this parliament passes a law, like you mentioned about the NJAC, parliament has passed the NJAC, it's a constitutional amendment. Constitutional amendment is passed with the 2/3 majority. Now, naturally, the parliament has the authority to amend the constitution. Now, when the Supreme Court says that it violates the basic principle, basic structure of the constitution or something like that, then parliament can disagree with that also. But then it will lead to a confrontation. Normally in governance system, everybody tries to avoid confrontation as far as possible. But if the confrontation becomes a must, nobody is averse to confrontation. But as far as possible, avoid it. Try to find a neutral venue where neutral point at which you can agree that, okay, we are prepared to walk a few steps, you also walk a few steps. We may not meet, but at least we are closer to each other. So this type of an approach is always adopted in any governance system. Confrontation is not going to help either wing of the government. That is why, knowing fully well that the NJSC verdict of the Supreme Court was not exactly logical or legal, the parliament is not prepared to confront. But a situation may come when parliament may come with another version of the bill that is walking a few steps closer. So parliament may like to walk a few steps closer. Supreme Court also may like to walk a few steps closer to the parliament, and things may get resolved. But confrontation has to be avoided at any cost. This is going to be the attitude of the civil servants also, that as far as possible, avoid confrontation. But if it is a must, it will be.
So, sir, shall we say that there was one incident where I think law minister or the judge of a Supreme Court has made a statement public with respect to the discussion they had behind the closed doors, and I think government said so that they should not come out in public and on these aspects.
There is a very thin line which separates a politician from an office bearer of the government. So sometimes people behave like politicians, sometimes they behave like ministers. So we cannot say that a minister should not behave like a politician. We cannot say that. Sometimes politics takes over and they go by what their political privileges dictate, or political goals are there which they have to meet. So this type of anomalies do take place. But we should not be very too worried about this type of comments, because that's all part of our political system. Khalistan movement. Okay, I'll just quickly go through the Khalistan movement and then I'll finish it. I will not have a discussion on the Khalistan movement. I'm only going to give you why I want to share the slide of Khalistan movement with you, that especially those of you from Punjab may face this question about Khalistan movement, and you should at least know the background. You may not be. I don't want to discuss the issues which are likely to come, but please have a look at the background of the Khalistan movement. The Khalistan movement is a separatist movement seeking to create a homeland for Sikhs by establishing a sovereign state called Khalistan. That is the definition. And some of the important landmarks in the history of Khalistan movement I have mentioned here. Is not an exhaustive list, because Khalistan movement started in the 1940s when the India's independence was on the cards, and some of the Sikh leaders wanted a separate country for themselves. So then in 1940 it was started. But then after the independence, it practically died down to some extent, but it was not completely dead. In 1973, there was the Anandpur Sahib resolution, where the Shiromani Akali Dal was also invited. That was a resolution which was sponsored by them, and there certain. I'm not going to give the details because I don't have the time. So please note these things and look at these things. Google them, and you will get enough material on that. So these are the things which you should know. Then in 1984, there was the Operation Blue Star, and also you should read about the Damdami Taksal leader Jarnail Singh Bhindranwale, who was killed in the Golden Temple of Amritsar in 1984, which led to the assassination of Mrs. Indira Gandhi also. Then in 1985, there were two important incidents. One was the blasting of the Air India flight 182, which was a Boeing 747 carrying 329 people flying from Montreal to Mumbai via London. It was blown up by a bomb mid-air. It is known that it was blown by a bomb, but the culprits have not been ascertained so far. Please read about it. Then there was a Rajiv Gandhi had become Prime Minister in 1984. He wanted to diffuse the situation, and he entered into an agreement with Sri Longawal, who was the leader of the Akali Dal at that time, Rajiv Longawal Accord, which gave several concessions to the Sikhs of Punjab, and also even to Punjab state, or many concessions were supposed to be given. Not all of them that was implemented. In fact, it included handing over Chandigarh to Punjab. That was also agreed in Rajiv Longawal Accord, and as you know, that has not been implemented. Then you should also know about the support of the Indian Sikh diaspora to Khalistan movement. Some of the pioneers like Davinder Singh Parmar and Jagdish Singh Chauhan, please read about them and how they became leaders of the Khalistan movement. Then another very important personality you should know is Simranjit Singh Mann, who was elected in 2022 from Sangrur. He's a MP who subscribes to the Khalistan idea. He is a leader of the Shiromani Akali Dal Amritsar, which is a pro-Khalistan party, and he has a representation in the Indian Parliament. Then you should also read about it becomes current news because of Amritpal Singh. He is a leader of the organization. He is a very young man. He is the leader of the organization called Waris Punjab Day. He had raised a private army called Anandpur Khalsa. It's a army with weapons, which was raised by him, and that is why he was sought to be arrested by the Punjab police. And you know the rest of the story, which is still in the news. Okay, I'll stop here and wish you all the best. It is 7:30 now. I don't have more time to share with you. If you have any issue, please attend the group mocks where I will be there, and there we can have more discussion. There will be one more panelist there, and we will be able to discuss more issues in the group mock. Please reserve your questions for the group mock, and wish you all the best. See you all in the group mock. I may be able to come on this Sunday or maybe on Tuesday. So let me see you all in the group. Thank you very much. Sandeep, you can find out.
Thank you, sir.
Dhanyawad, sir. Have a good evening, sir. Thank you, sir.